The earlier order will not be corrected. This will be treated as a corrected order of that date. How can the order which is uploaded be corrected?
Okay.
The clarification will be there in the next order.
Okay.
That can't be corrected. It has already
My
been
loss.
uploaded. Can't be taken down and
Deal or see, I appear for the petition.
yes.
All right. Page 59, my lord, the ordering to the 17 July 2026. A notice for disconnection of electricity supply due to non-payment of
Page
outstanding.
59.
Page
59.
Page 59.
Yes.
And each petitioner has manually paid the entire dues as per the provisional bill has been raised by the marriage department. Kindly come to page 17.
Yes.
That is outstanding bill is 53,973. And I have
70.
only page 17, 17.
17.
This is outstanding. Thereafter, no final assessment bill has been raised by the department. Now the petitioner went to the civil court also. He preferred a title suit. Thereafter, title has been preferred. There is an order of injunction regarding the payment of the bill. That is kindly come to page 37. The respondent serious station measure WBGC is restrained from realizing the outstanding bill amounting rupees 53,970. The bill dated 27/8/2014 till the hearing of the petition section 5 limitation act. Thereafter, this petitioner has paid the entire bill, page 38 and onwards. That is the money receipt. Though, my lord, the department has raised the outstanding bill of rupees, my lord, the amount of rupees 1,05,000.
Yes, Mr. Nayak.
My lord, this is not an outstanding bill. This is not LPSC. What happened from 2011 to 2015 onwards, 16, the amount was not paid. Time to time, he took time or whatever it is, ultimately amount is paid. But the LPSC amount that was created and that was not paid. And that amount comes to 1,05,249 as on date. Now what happened, he made representation. Representation is under consideration whether this could be waived or not. That is under the process, the authorities is deciding this. At this juncture, since outstanding amount is LPSC and he is not paying, a notice has been issued, Lordship. That's the matter.
The entire bill has been the paid as per the matter. Now he has to raise the bill of the LPSC and other charges.
If the entire bill has been paid, then LPSC charges for what?
From 2011 to up to that time, 16.
That is not.
That is the period, when it was not paid. There was also one fault, not fault, the system change, because ultimately the legacy system, the amount was generated. He never approached it for making payment. But when SAP system was introduced in 14 onwards, that amount was not brought forward. So that escaped the notice of the WBC TCL. When it came to the notice, immediately it is intimated, they have cleared the amount. There is no dispute. My instruction is this, that amount has been paid. But LPSC has been generated in the meantime. That amount comes to 1,05,000 and odd.
And
he made representation for consideration.
What happened to the civil suit?
Civil suit, my lord, there is a civil suit has been dropped by the trial court.
You have challenged the provisional or
provisional bill. This bill.
How suit was maintainable?
Well, that the trial court up to the holding that it has been restraint order has been passed. Kindly come to page, my lord. The
suit is alive.
36 onwards. That is 37 is the ordering.
Suit is still alive.
That to that extent, I have no specific instructions. Only, I have taken instruction that the amount is arising out of LPSC for delayed payment, and he made a representation for consideration that is under process of consideration.
So you have disconnected his line?
No, disconnected. There is no regularly I am paying the bill. My lord, there is no disclosing. Kindly come to page 59.
Can you pay the LPSC in installments? I can provide for that.
My lord, regarding the LPSC installment, then which period they have been disclosed, not disclosed.
For the period during which the main bill remained unpaid, on that the interest will
amount has been calculated, breakup will be given.
My lord, they have to first decide whether the has to be chargeable to me or not. First, they have to decide the such issue. This bill has not been.
I don't want to advance argument at this stage. Delayed payment, it is always chargeable according to law. But sometimes, it can be waived also. So scheme is different schemes are there. My lord, authorities are considering this. I must be, my lord, candid on my submission. That's my instruction.
Where is the representation made by him?
Perhaps he has not made here, but before us they have made. That's my instruction.
They have not annexed to the representation. They have been asked by representation to the client, but I have not annexed the copy of it.
Then what order will I pass on this? I cannot just set aside their.
Yes. My lord, let him make the payment in installments, whatever he likes. My lord, if it is ultimately waived, it will be adjusted.
But
against
what is the amount that is payable?
Yes, it is given. It is in the notice. 1,05,249.
Now, assessed LPC amount 83,706.44. Why?
Page.
That is page 59.
Page 59.
Records amount of rupees 1,05,263.45. But assessed LPC amount rupees 83,706.44.
59.
What is the meaning of this, Mr. Nayak?
Excuse me, Lordship.
A record indicates that an amount of such and such, and assessed LPC amount of such and such. How two amounts can be due? On what basis two amounts are due?
5,003 rupees at this one. So, assessed LPSC amount, rupees this. And on today remains. My lord, I need clarification. My lord, I will not add any word on this of my own.
Because there are two amounts due. It is not only LPSC. If
Here
he
they
has
have
already paid
no.
one.
Two amount generated because the entire earlier the amount was my lord 53,970. My lord, that was on 19/8/11. My lord, he paid 27,000. That is by 12. Thereafter, the remaining amount was not paid. That paid later on in 15. In
Yes,
this,
but this is the bill of 17 July 2026. In 2026, you are raising 1,05,263 and
my
83,000.
lord, the breakup amount they have given two amount. One is 25,000 for
But
earlier
LPSC
amount.
LPSC is only 83,706.
No, 79,000 something later on for the rest of the part. My lord, 17, he paid around 66,000. My lord, in 12. 11 it arose, in 12 he paid. Rest,
Very well. He has paid the main bill.
yes.
If he has paid the main bill, then what remains to be paid is only LPSC.
LPS.
Now, this letter at page 59 shows two charges. One is LPSC, one is something else. What is that something else?
My lord, I need clarification on this. My lord, I can't, my lord, clarify this.
When can you come back with clarification?
Monday? No, Monday or not Tuesday?
The petitioner is aggrieved. Mr. Guha Thakurata,
Yes.
one point which you have considered Muthoot Finance, Shobha De versus Muthoot Finance,
Yes.
2025 judgment. That was not placed before the Honorable Division Bench nor before the Honorable Single Judge.
Yes.
Now, in view of that, how would the writ petition be maintainable?
Well, there is,
If we do not go into the questions at all, how would the writ petition be maintainable at the threshold?
then can you fix a date on Monday? I shall address because today I am not carrying that judgment.
That was
I think in that judgment there is some window. There is some
Difficult.
window I can enter into this.
the Muthoot Finance judgment clearly
P
says that,
category says P category.
clearly says that it does not fall within Article 12. Therefore,
But any organization discharging public duties, whether it is a public
that has been considered in Muthoot Finance.
Muthoot Finance, yeah.
Yes, it has been considered. Exactly this argument was made, and High Court had entertained. Supreme Court said no, you cannot. You have your other remedies. If you don't have the DRT remedy, avail of civil remedies, but not the writ court. This argument does not
But
appear to
this
have been
court-
made.
This honorable division bench
This
also consider-
Shobha versus Muthoot Finance was not placed.
yes, but
It was not placed.
court has given a own reasoning. Why, my lord?
Shobha versus Muthoot Finance is binding on all of us. It's Supreme Court. If it is not placed, not considered, then that judgment will not help you. Shobha versus Muthoot Finance is Supreme Court judgment. It is not High Court division bench. That was
Why
not.
is the judgment, my lord, when that issue is considered by the division bench? Why, my lord, alternative remedy is not applicable?
It is not a question of alternative remedy. Alternative remedy will be a question when this writ is maintainable. Against a private person, writ is not maintainable. Against a private, merely because you have added state of West Bengal as a party does not make it maintainable if it is otherwise not maintainable.
Court has given reason because
Because your
without
right to relief,
jurisdiction-
your right to ultimate relief is against the private respondent.
Yes.
Your right to ultimate relief is against the private respondent.
Well, then, well, can you fix it on Monday? Well, I shall address on this point.
Monday will be difficult.
Till
We
the
can have it on
interim order
Wednesday.
to extension.
Wednesday.
Likhen in,
Interim order.
as prayed for by Mr. Guha Thakurata, list this matter.
In this matter, last night at 10:30, I got the instruction to appear on behalf of the private respondent. I have not yet received the brief also. Therefore, they are coming from Bankura. Can it be adjourned to any day next
My
week?
lord, this matter, my lord, requires my lord report because a gross of suppression, my lord, has been made in the report.
What is the writ petition about?
This petition is, my lord, my lord, the petitioner has alleged that we have changed the name of the SSC. I think, my lord, name of the consumer, sorry, my lord, name of the consumer. Now, my lord, it has been framed, this petition has been framed as if, my lord, they have made a representation. We have conducted hearing for 2 days, nothing was done. Challenging inaction, the petition filed. My lord, he has transferred the name in the name of the private respondent. That has been suppressed. Now he has, my lord, the private respondent, my lord, along with an affidavit with all documents, including the cell deed, prayed for us with an affidavit. If there be any discrepancy, you are at liberty to disconnect. On the basis of your process, my lord, change the name. Now this has been suppressed, that he has, my lord, changed the name, he has transferred the
And what
property.
does he want now?
Now he wants, my lord, hearing to be given.
Hearing for what?
Hearing for, he has made a complaint. We have, my lord, evidence given. We have conducted hearing for 2 days. We have not passed any reasoned order. Now that is, my lord, challenging the inaction. Well, actually, my lord, should have come, my lord, with proper facts, my lord.
Yes,
This has
my lord.
happened.
I'm submitting, my lord.
Let them file a
The
report.
petitioner is the bona fide consumer of,
File a report.
yes. My lord, illegally the name of the private respondent has been inserted in my consumer.
The petitioner.
3 occasions hearing had been held.
Parties are here, my lord. Net friend is also here.
The other party, Arsil,
Arsil, my lord, I have been informed today that I am also to represent Arsil.
you will represent
I will
Arsil.
represent Arsil.
Then I have kept it on Wednesday. Please come on Wednesday.
The other Muthoot Finance.
Yes.
Yes,
Lord,
my
if I
because my
may-
lord, I found another judgment of Piramal of Phoenix ARC of 2022, where it deals with the surface issue as well, where under surface action, the court can be approached or not if a surface action is initiated.
Right, right.
Lord,
right.
the only thing is that I don't think.
Even if the threshold is not met, please consider Muthoot Finance and
Yes,
then come.
my lord,
Please
on that,
appear on Wednesday.
the only thing is, my lord, that the right to property is still a constitutional right.
Suppose I dispossess you from your property.
Yes, ma'am.
Will you file a writ against me? I'm
No,
a private person.
As a private person, I would.
Then
But my
that
lord,
logic applies.
here the
What will be your remedy? Civil suit, get an order of
But my lord,
injunction, restoration
where
of
my
possession.
constitutional right is violated, my lord, under 226.
Equally constitutional right even there. Against whom is it available as a constitutional right and against whom is it available as a private right?
Right, yes.
That is the distinction that you have to make. Because then in that case, there will be no requirement of a civil court. All private actions
Yes,
will be
ma'am.
writ actions.
Yes, ma'am. That is true.
So lack of jurisdiction, going to the root of the jurisdiction, all these issues will be material only if the authority whose action you are impugning is an authority which answers the definition of a state. If it does not answer, then in that case,
But my lord, the other thing is that, my lord, I don't think, my lord, is because of the the division bench decision prevailing on this issue, my lord. I think, my lord, this matter will have to go up to a division bench for it to be finally.
Muthoot Finance is Supreme Court.
That's also there. Yes, ma'am. That
My
is
lord,
also
that
there.
That was not placed.
No,
considered.
ma'am, that is not placed.
That was not considered.
Very
That
well.
aspect. That aspect.
I have to discharge a public function. Then will I come under?
We'll place our arguments. This is on
please,
the on the 18th.
Wednesday.
Wednesday.
Nice. Next. What has happened? Sale has taken place.
My lord,
My lord-
only his client can.
My lord, today only I have been informed that I am representing RCL. I do not have any
Tell me, if
instructions.
sale has not taken place, this in any case will go.
No, my lord, this is challenging the route of from 13 to onwards, my lord.
There's no immediate cause then.
I will take the instruction, my lord. I haven't received yet.
Yes.
My lord, affidavit of service is not completed, so I am praying to time, my lord. Affidavit service not completed.
Not this week. Not this week will do. Not today will do. Only not today will do, or you want
Yes.
longer time?
Not today. Time, praying time.
নট টুডেতে হবে আপনার আজকে নট টুডে হলে হবে
হ্যাঁ, আচ্ছা।
Not today.
সোমবার থাকবে
Well, this is the matter Mullah took up yesterday. We've also served on the private respondent's advocate Mullah. I'll just indicate. Now, this is the letter Mullah. Yesterday we served, informed them also that the matter will be taken up today. I'm just asking for an order Mullah in a similar matter. Mullah, we'll just have this once. This will
Service
be-
otherwise is complete.
Otherwise is complete. Again, I have served yesterday Mullah, since the matter was made not today. I served on the done an advocate for the private respondent, and she's accepted service. Well, that map, my lord, will help. Okay, well, they're appearing.
You are there.
Lordship, I am for the respondent number 6 and 7. Give me short pass over my client.
I'll just direct
Just
no
this order.
inspection to be done.
That's all. That's all.
what
inspection.
happened when they filed the writ petition for new connection, they raised objection. According to them, pole cannot be installed in their premises.
This is the order pass.
When my lord, this petitioner filed writ application for new connection,
They have raised objection.
Yes. So, my lord, similar order to this can be passed.
the
It is
counter
in a
now,
connected that.
one thing, my lord, I will make a request to my landed junior, my lord, that my lord, what is the report is that initially when the two inspection has been done, meter room was not ready.
Has been
Like
constructed.
if that be
It's made ready. It's made ready, my lord, to record
The
my.
petitioner here,
Yes.
or in respect of both the
No,
parties.
no, in respect of my plot, that was the objection initially raised, but the last letter of the CSE does not record that
Has
objection.
inspection in terms of the last order been done or yet to be done?
yet to be done.
So same
Joint,
one
yes,
inspection
my
will
lord.
suffice for
Yes,
both.
my lord. Yes, my lord. Yes, my lord. Should. That's why, my lord, the map, my lord, we'll see their plots of land located close to each other. That's all.
लिखे नहीं. Affidavit of service.
I will give it to your lordship.
Please.
Yes, next.
In this matter, I am appearing for the prisoner, my lord. I have sent, but service has not been completed, my lord. Yeah, done.
It can be, if I keep it, make it not today, can it be done? No.
No, Monday.
Think for not to.
Not today. Not today.
I am for the applicant, my lord. They have service. And since very beginning, content may not appeared, my lord. Kindly come to the second last order, my lord. Or sixth order. Action.
There has been a lot of change, Mr. Das. Serve again, because in between lot of changes have happened. Matter of 2025. Serve again. Serve a notice also on the government pleader's office. I'll direct you. Let us take it after that. Maybe the officer is still there, or has he
My lord,
changed?
stay there.
Because on last two occasions you were also not there. Nobody
Not-
was there.
Yes, my lord.
20th February nobody was there. 7th August nobody was there.
My lord.
Affidavit of service filed in court today.
This has been served, my lord.
लिखे नहीं. Affidavit of service filed in court today is taken on record.
My lord, I may appear on behalf of the petitioner, my lord. First day contempt application appearing in the your lordship list, my lord. Your lordship order, page 18. Non-comply your lordship order. Direction among the SDO Canning, my lord.
But he has not taken decision.
No, my lord.
लिखे नहीं. This is an application for contempt.
Non-compliance of the order, lordship. Order is on page 12. There was a direction upon the collector to consider my representation within 4 weeks. After
Nothing
the,
has been done.
nothing has been done. After communication was effected on 19th November.
WPA number টা চেঞ্জ করে দিন. WPA 19990.
Lordship.
Next.
My lord, I am for the petitioner, my lord. First time, my lord. First time for
First time. লিখে নিন. ওই সেম অর্ডারই হবে. শুধু অর্ডার ডেট হয়ে যাবে June 10, 2025. WPA 1184720. সেম অর্ডার সার্ভিসের. 11 সব 11.
This is for the restoration application. Which is the one?
When was it dismissed? And what is the grievance? What is the main matter for?
Grievance is that, my lord.
Main matter?
Main matter is that decimal number 5, once upon a time, in my as a tenant, he was enjoying the property, and after became my petitioner, after became ownership, he has no connection with the property. In spite of that, he's enjoying the one room. That is fine. But I made an application under RTI application to the legislature of the opposite for providing ID number of that decimal number 5. That was not considered. Page
That is an
31.
appealable order. If he has not considered, you should have filed appeal. Why read? If RTI application.
I can invoke read jurisdiction also. Page 31.
Why? You have your remedy. Why should you come to the writ court running unnecessarily? You have your appellate remedy before
And
the
the
first
page
appellate
31,
authority.
Because he is unauthorized,
Unnecessarily come and
trespasser.
burden the writ court like this.
He is completely trespassers, my lord.
Whatever it is, you are aggrieved
But
by the non-furnishing.
even let it forgive the RTI. Even not
You are
considered.
aggrieved by the non-furnishing of information by an authority under the RTI Act.
Yes,
There is
madam.
an appeal provision.
If we bypass that RTI also, simple representatives are not considered there. Not considered, sir.
What is the representation? You want information. That is the
Page
representation.
31, page 30 and 31. When it petition.
Yes.
Page 30. To conduct an inquiry, how is enjoying the electricity in my property. That was not considered.
If he is in settled possession, he will enjoy the property. Merely because you have filed a suit, you want him to be evicted.
At
That
least,
is
they
neither
should
here
have,
nor there.
at least they should have considered the representation also.
Mr. Bandyopadhyay, what will you do? You will consider the representation. Consider it and dispose of. लिखे नहीं. Can one
Seventeen, my lord, I am for the
My lord, I seek for a short passover, my lord. The counsel for the petition is on his way.
petitioner, এই তো petition. লেখা বলে ভুল।
Apologies, my lord.
My lord, actually, Mr. Saeed is the advocate on record in this matter. Mr. Saeed, my lord, he is the advocate on record. My lord, this is a restoration application, my lord.
What is the main matter?
Main matter, my lord, I purchased a land from a person. Before that, my lord, there are 3 transactions with my lord other persons regarding the same property. Now, at this juncture, when I made an application for my domestic connection, The WBSC asks me to deposit 5 lakhs rupee as outstanding dues and the LPSC charges. I filed a writ petition. I filed a writ petition before this honorable court. The honorable court directed the SCDCL to pass a regime order establishing the nexus in between me and the defaulter. They failed to do so, but they only said there is a nexus. Challenging that order, my lord, I am before you.
Where is the reason?
Reason, my lord, kindly come to page 83. 83.
83. Yes, page 83. Paragraph 1 shows you have used the same electricity connector.
No, that is not correct.
How do you say it is not correct?
My lord, the property handed over to me in the month of June 2022. After that, my lord, I filed this writ petition.
How will they know when was the property handed over to you? You are supposed to be handed it over. What is the document to show that you have been handed over? You can make it out at your home. These documents can be created at home. This is a private document.
My lord, there are other documents, my lord, I need to use and supplementary affidavit, my lord.
It has been registered in 2020. They have
If
to
it
give
has
that.
been registered in 2020, where is your deed?
My lord,
deed has been
deed
annexed.
already annexed, my lord. Page 40.
Page 40.
40.
Page 59. No, 59. Starting from page 59, Lordship.
Page 59.
Kindly see that it has been registered
8 June 2020.
and the liability will come into force after the purchasing. This is the law. And on that basis, that there was a connection which is in live condition in 2021 also. There is no deny, there is no dispute on that.
Lord, my deed is at page 21, my lord. I'm sorry.
This is not your deed.
No, that is my lord. I purchased from whom? That deed.
Page 21.
Yes. My lord, may I hand over a short list of debts, my lord?
The page 21 also show that it's 2020. Yes. There is no dispute.
My lord, kindly see, my lord, the original owner is my lord Sheikh Abu Bakr.
Yes.
My lord, in March 2012, my lord, the domestic electric connection was given to Mr. Bakr. Next, my lord, in 2016, Sheikh Israel, the son of my lord Abu Bakr, the industrial connection was given. In 2018, the property gifted to his son Sheikh Israel by Abu Bakr. Next, in 2020, my lord, the Bimangiri purchased the land from Mr. Israel. In 18 December, in 1st December 2020, bill raised for the industrial connection 78 lost. I have document to show that there is a declaration by the residential, there is no due in respect of the property or connection. In December 2020, my lord, I purchased the land. This is not undervalued, my lord. I have put the market price and the my lord, stamp duty and others. In March 21, my lord, domestic connection was disconnected. Thereafter, my lord, June 2022, my lord, possession was given and I made an application for electricity connection. Yes.
Becomes difficult.
No, they have,
Both ways, 13.9 and 4.6.4. Both ways
they
you
have
are
to
going.
they have to prove a nexus in between me and my lord the Abu Bakr. If my lord there is a due for the region of Mr. Bakr.
The problem is you have taken the property with a live connection. If it was a case where it was lying disconnected for 180 days, then you could have gone out of the rigors of 4.6.4. In terms of 13.9, you could have been only asked to pay the pro rata charges. But 4.6.4 live connection, Justice Datto's division bench judgment.
My lord, I have the answer to the Supreme Court judgment with the Supreme Court. My lord, kindly give
The judgment of the Supreme Court, which you have referred to here, has considered that judgment of our division bench, headed by Justice.
my lord, I know I have the judgment also, my lord. My lord, I put my lord 3-4 paragraphs from there, my lord, to stand by case.
I am restoring it. Come back. When do you want to come?
On any date, my lord. April.
You are ready today?
My lord, I have to, my lord.
Very well. Then tell me when day. When?
On any day except 21st August. Friday. My lord, item number 18, we are for the respondent.
Your
bank.
Lordship, I beg to appear for the petitioner virtually.
Yes.
Your Lordship, this matter was dismissed on 24/10/25 and it was can application has been filed
What
on
is the main
19/11.
matter, sir? What is the main matter?
Your Lordship, the main matter is that the cooperative bank has issued the 13-2 notice claiming the illegal amount, Your Lordship. The loan was taken in the year 2017. The principal amount was rupees 20 lakhs, against which till date I have paid rupees 33 lakhs, Your Lordship. There was a LIC and other document which has been redeemed, but the loan statement does not reflect the such amount. As such, I have made representation for updation of the loan account and regularization of the account also. I am a widow, Your Lordship. Meantime, my husband has died. Therefore, I want to settle the loan account, but the bank is not ready and willing to do the same. The 13-4 notice has not been issued till date, Your Lordship.
Why are you not updating his loan account? He says that he has.
My lord, honor before making submission before. It has been dismissed by Honorable Justice.
That I will restore. That is why I asked him to
Dismissed
make
by
submissions.
Amrita Sinha.
Very well. That I
Second
can
of all,
restore.
my lord, this is his submission from bar. Several times settlement tried to settle the issue. Bank has no intention not to settle. Why not? Several times. The delay notice was issued 23rd. 23rd, 23, year 23.
Where is your document of LIC? Please wait.
Your Lordship, therefore, 1 month time may be given. Meantime, I could send a fresh application for settlement of the loan account. Let the bank consider the same.
You can always approach the bank for settlement, but I cannot pass a mandatory order directing the bank to enter into a settlement with you. You know the judgments.
Yeah, Your Lordship, I'm praying for liberty, Your Lordship.
Very well. Likhen. Can 1 of 2024 is an application for restoration of WPA 16081 of 2025 that stood dismissed for default on October 24, 2025. Full stop, paragraph. In view of the good ground shown in the application for restoration, justifying the non-representation of the petitioner on October 24, 2025. The order dated October 24, 2025 dismissing the writ petition for default is recalled. Full stop. WPA 16081 of 2025 is restored to its original file and number. Full stop. Can 1 of 2025 stands allowed. Full stop. Ever RE WPA 16081 of 2025. The petitioner is aggrieved by the action taken by the respondent bank under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. Full stop. Paragraph. The petitioner's remedy against the action of the bank under the 2002 Act would be before the relevant debts recovery tribunal. Full stop. Paragraph. The petitioner further submits that the petitioner is interested in getting the loan account settled and is willing to make appropriate representation before the respondent bank for consideration thereof for the purpose of settlement of the loan account. Full stop. Paragraph. In view of the settled position of law, bracket likhe din, Arvindra Electronics and Bijnor Cooperative, bracket closed kore din. No mandatory order can be passed by this court directing the bank to enter into a settlement or a compromise. However, the petitioner shall be free to make appropriate representation to the bank seeking settlement of the petitioner's loan. Full stop. If such representation is made, comma, the bank shall be free to consider the same in accordance with the norms applicable to the bank and the law governing the field. It is clarified that the decision of the bank would be its own, and there is no mandate of the court to enter into a settlement. Full stop. WPA 16081 of 2025 stands disposed of, no costs.
My lord, kindly
Grateful, Your
get, my lord, get it under your lordship jurisdiction. Because of that, it's several times and kindly fix another date in the meantime.
I have disposed of.
Grateful.
Consider and dispose of is if he makes a representation, consider that and dispose that of. If you can see that they can be, it can be paid, consider it, finish it off. লিখে দিন ওখানে. The bank will consider the representation in the right earnest. এটা এখানে ঢুকিয়ে দেবো আমি.
What happened, my lord? Bank will
consider the representation in right earnest. Yes.
Okay.
The service long back until July.
What is the matter?
My lord, this is the
demarcation of the land.
my lord, may I submit, my lord, for the petitioner.
But the main answering respondent possibly would be state.
My lord, the short facts in this case, my lord, short fact in this case, my lord, for the purpose of construction of the road, some
When did you serve? 24th of July service was not there.
no,
That is the recording.
no, that is a 24th in time. 1 minute.
There is an issue of maintainability.
30th July.
Of course, why not?
It is 30th July.
Lord will kindly have a look at paragraph.
My lord, notice has been served
18
30th
at page
July.
9.
30th July has been served.
Yeah, July, yes.
Paragraph 19 at page 9.
Key.
Possibly this writ will not be maintained.
Paragraph 19
Yes.
at page 9.
Yes.
Yes.
Kindly sees my lord the last two lines. The last 4 lines. The writ petition was withdrawn by order dated such and such, passed by his lordship justice such and such, with liberty to file a fresh writ petition on the same cause of action. Kindly seize this order, which is page 73.
কোনটা থেকে বলছি?
I do not find any liberty granted to file on the same.
Not pressed. Sarguja.
Sarguja, I am
Sarguja.
Sarguja, I am carrying.
What will happen?
And
Justice
in the
Gogoi.
pleading-
Sarguja is Justice Gogoi.
Not pressed.
Then
No merit, no order has been passed.
This is MM Dutt.
you have not prayed for any liberty. Not maintainable. Public policy.
That is true, my lord. In fact, my lord,
Line is that it will not be res judicata, but it will be barred by public policy.
in spite of that, so far my little knowledge, my lord, in for my lord,
You have
No.
Sarguja.
no order has yet been passed, my lord.
Please see Sarguja. It is absolutely
Kindly
applicable
have
to
a look
writs
at-
only.
The last paragraph. Paragraph 9. Last page. The point of, may I place it, the point of
Paragraph 9.
consideration is whether a petitioner, after withdrawing a writ petition filed by him in the High Court under Article 226 of the Constitution of India, without the permission to institute a fresh petition, can file a fresh writ petition in the High Court under that article. On this point, the decision in such and such is of no assistance. We are of the view that the principal underlying underlying Rule 1 of Order 23 of the Code should be extended in the interest of administration of justice to cases of withdrawal of writ petition also, not on the ground of res judicata, but on the ground of public policy.
Yes.
As explained above.
But the grievance of the, my lord, the grievance of the,
This is still good law. It was ultimately in that Assam judgment also this was referred to by Justice Gogoi later on. I remember. Assam Sammilani or something. difficult. I'm
Then I, my lord, say come back, my lord.
in terms of the earlier order.
Respondents.
There was a direction.
They were there on the previous.
Last occasion, they were not there. That is the recording.
He had informed. I'd informed Mr. Somen Bhattacharya. I'd informed him.
Because there was a direction on you to serve notice.
I apologize. I'll check my.
None appears for the respondent.
I am for the petitioner. But the rigors of Section 7 of the West Bengal Premises Tenancy Act is haunting your lordship.
Why, what happened? That's legislature's intention, not my rigor. And the Honorable Supreme Court has been very strict.
But we are trying to find something out of nothing.
Only if you can find it there, we will be able to find, enter.
But I do not know what has happened, my lord, because
We
so
can't
many-
enter if the doors are closed there.
7th August কি যে হলো কারা করলেন মামলা
Because the language is such that you can't find an escape route. And the High Court, of course, cannot, because it's Supreme Court. Only Supreme Court can say.
But here is a situation where the 7-2 application was taken up for hearing. But at the time of disposal of the 7-2 application, the learned court below held that you have not complied with the 7-1 particulars. Whatever order was there, that was incorrect. Passed by the court. Accordingly, your defense is struck off. But certain dates are very important in this matter, my lord. Lordship, I would point out the dates. Malad, the summons was served upon the defendant on 29th of September 2022. Malad, that was the last date before, Puja vacation. On that date, it was received. But this is admitted position. Malad, thereafter, this finds reference in the order. On the date of reopening, 7-1-7-2 filed. But therefore, there cannot be any delay. On the last date of functioning of court, it is received. The very opening day, it is filed. Malad, thereafter, 7-1 and 7-2 were, these were two were filed on 28th October 2022. Now, this 7-1 got allowed on 28th.
Please, once more, please, the dates once more.
But summons received on 29th September 2022.
29/9/2022. Yes.
Last date of work. But court reopened on 28/10/2022.
28/10.
Yes.
2022.
7-1-7-2 filed on 28/10/2022.
7-1-7-2 filed on the same day.
Yes. On that very date. But the 7-1 got allowed by the learned court below on 28 February 2023. 28 February 2023.
Yes.
Malad, the defendant numbers 1, 2, 3, they deposited the amount on 17/3/2023. I'm sorry. Defendant is one. Defendant deposited in on 17/3/2023. There is only one defendant. Malad, in the meantime, something had happened. Malad, that is
17/3/20th March ডিপোজিট অ্যাপ্লাই হয়েছিল একটু চেক করে নেন কারণ আমার একদম অর্ডার থেকে করা আছে but my learned senior friend says it is on 17th March. My learned junior has checked up the record. He says that it was deposited on 20th March. I was only Milord corroborated with my learned friend. That is
20th March.
Malad, I'm sorry, Milord, it is 20th. 23/2022. But still then, but 1 month gap, if any, would be the same. But in the meantime, what had happened? But we had filed our written statement. We had stated there, we had landlord-tenant relationship only with the plaintiff numbers 1 to 3, not the others. 4 to 6, we did not have any relationship. But the other side filed an application under Order 1, Rule 10(2), seeking for withdrawal of their name from the array of plaintiffs, and they were made pro forma defendants. But this has happened. The deposit regarding 7.1 and 7.2 was made on 20th March 2023. Now, my lord, kindly comes to the order that has been passed by the court. The impugned order, lordship may kindly consider. My lord, these have all been recorded, my lord, in the order sheet. My lord, kindly comes to the third page of the order regarding the transposition. It is in the middle portion.
Yes.
My lord, that is there. Now, my lord, I would be taking your lordship to the last but one paragraph. In this regard, the learned advocate for the defendant, lordship has got that paragraph. Last but one paragraph. Third page.
Third page.
Of the impugned order.
Yes, in this regard.
In this regard, the learned advocate for the defendant tried to impress upon this court that there was no specific direction in the order dated 28/2/2023 passed by the learned court under section 7(1) of the WBPT Act, requiring the defendant to deposit the arrears of rent positively within any fixed date. And in such circumstances, the defendant was required to make such deposits within a period of 1 month from the date of passing of the said order on 28/2/2023 in terms of the provisions of section 7(1) of the WBPT Act. Now, my lord, kindly turns the page, my lord. Paragraph, page 4, the first paragraph. In this regard, it is submitted by Mr. Gupta that there is a practical difficulty in making deposits towards arrears of rent, since without an order of the court permitting such deposit to be made, the office of this court does not accept such deposit. But I stop here for a moment. At the small causes court, there is a system. But in a city civil court, they do not accept deposits without the court orders. Both in the small causes court and the city civil court. A party cannot go to the, the department concerned and pass the challan and deposit any amount, and thereafter bring it to the notice of the court. It has to be first ordered, only thereafter this deposit has to be made. My 7(1) order was not passed. It was kept pending. But kept pending for certain reasons. They wanted to give objections also. So I will show that. Now kindly comes, my lord. My lord, kindly see. We had referred to a judgment, the next paragraph, page 4. Messrs. Smart Enterprises versus Sriram Trust. My lord, the portion of the judgment has been quoted. Strictly speaking, 7(1) of the Act does not conceive of any application being made thereafter, but a practical difficulty arises in a deposit being made in court without anything in writing. Thus, a practice has developed whereunder an application is made under section 7(1) of the Act, even if only to make good the default or pay the entire amount that is perceived to be due, at least for the first time. The monthly deposits may be more easily made if there is a file open in the department of the concern of the relevant court in the name of a particular suit, where at least one previous deposit has been made. Well, thereafter it was opposed by the other side. That has been taken note of. Other side had submitted that 7(3) had started its operation because the current month deposit for February 2023 ought to have been made within 15/3/2023. But although it was pending, Malat now kindly finds the next page, my lord, third paragraph. Page number 5. However, Mr. Shaharoy argued that the defendant initially consumed a period of 29 days from the date of service of summons upon her to file the application under section 7(1), and thereafter during the entire period of pendency of the said application before the court till its disposal on 28/2/2023, the defendant simply avoided her responsibility in making any deposit towards rents on account of arrears or current months, and particularly she killed time on this pretext. Matlab, this entire period was the puja holidays.
Puja holidays began on 29 September.
29 September 2022. And on 28th only the court reopened, we submitted. Matlab, thereafter, several judgments have been considered, matlab, which Lordship has already considered in very many matters. Devashish Rai, matlab, Parvati Charan Rokhit, West Bengal Handloom. Lordship is aware of these judgments. Matlab, these are all in respect of 7(1) along with section 5. A part of it is regarding condonation of delay. Matlab, here our case is different. Here they cannot show or demonstrate before the court that we have delayed for a single date. We couldn't have acted at a time when it was for the disposal of the court in between the puja vacation. Malad now kindly turns to the 7th page of the judgment, Malad. Malad, here Bijoy Kumar Singh, Amit Kumar Chamaria and Devashish Paul, these have been quoted. Malad, the provision of section 5 do not apply, that has been quoted. Now, Malad, kindly turns. But in detail, the trial court has taken care of all this. Now, I would invite your Lordship's attention, Malad, to page number 12 of the judgment.
Consideration.
Well,
Lordship will also consider para 10, Malad, as page 10. I'm sorry.
Page 10.
Page 10.
Discussion starts from there.
Well, a lot of discussions, everything discussed.
Paragraph of page 10.
But on consideration of the case, but it starts there.
Reasoning of the learned trial judge below is there.
Yes.
Lordship will kindly turn to page 12. Middle portion. The defendant admittedly received the summons of the suit on 29/9/2022. In the background of the above factual position and in view of the settled position of law discussed in detail hereinabove, the defendant was mandatorily required under the provisions of Section 7 of WBPT Act 1997 to deposit the amount admitted by her to be due from her on account of arrears of rent, along with an application for determination of the rent payable within 1 month of 29/9/2022, that is within 29/10/2022. Needless to mention in this regard, this court had reopened on 28/10/2022 after puja holidays, and also since the court was open on 29/10/2022, the fact that this court remained closed from 1/10/2022 to 27/10/2022 has no relevance in the present case. As noted earlier, the defendant entered appearance in the suit on 28/10/2022 and filed an application under 7(1) of the WBPT Act on that day. However, as noted earlier, it has been specifically held by the Honorable High Court in West Bengal Handloom that Section 7(1) of the WBPT Act does not contemplate filing of any application. Such being the settled position of law, there was no legal stipulation for the defendant to file the application under 7(1), in order to make the deposit or to make payment towards admitted arrears of rent within 1 month of service of summons on her on 29/9/2022. Accordingly, the pendency of the said application under 7(1) cannot come to the aid of the defendant in this case. My lord, this is something which we differ, my lord. My lord, humbly we should submit before your lordship, my lord. But this is not the actual case. Without an application, amounts cannot be deposited. Nobody has up till now deposited, the court doesn't accept. Now, the next paragraph, lordship would kindly consider. Moreover, at no stage the defendant brought it to the notice of the court that though she intended to deposit the admitted arrears of rent within 1 month of service of summons, but the office of the court refused to accept the same. As such, the plea taken by the defendant in this regard also has no base to stand upon. Now, my lord, kindly, I would skip over 2 paragraphs, my lord. Lordship can kindly consider that also. My lord, I am skipping over 2 paragraphs. Thus, this court has no hesitation to hold that the deposits made by the defendant on 23/2023 towards arrear of rent and the current month's rent for February 2023 are not valid deposits in the eye of law, since such deposits were being made beyond the mandatory time limits specified under the provisions of 7(1). As noted earlier, the objection raised by the defendant in the instant application under 7(2) of the WBPT Act regarding landlord-tenant relationship between the plaintiff numbers 4 to 6 and the defendant has lost its force at present by transposition of the said plaintiffs as pro forma defendants in this suit, and the defendant admits the present 3 plaintiffs of this suit as are landlords in respect of the suit premises, and accordingly no further order needs to be passed by this court in this regard. With the above observations, instant application under 7(2) of the WBPT Act stands disposed of. Defense against delivery of possession is stopped. Now, let twofold submission. Now, let number 1. Now, let 7(3) was invoked by the court without following the due process of law.
How long will you take, Mr.
But some judgments are there.
Because from 12 noon onwards, I have a fixed matter. We'll have it next Friday, assigned matter.
But kindly a cushion of, because they are proceeding before the trial court.
Not immediately, then my learned friend.
When is the date?
But it is in the peremptory hearing of this.
They have filed the chief also.
They have filed the chief.
18 September.
Very well. Next Friday we'll take up. Can you?
That's it. It should be an understanding without any order. They should not.
18 September is the date.
No, it's written in the order itself.
Judge,
that Bachawat was making his submissions, we had concluded on facts, on the judgments, we had indicated that we'll file a note distinguishing on facts, we'll distinguish the judgment. We'll file the note, my lordship will give us 1 or 2 days. When my learned friend
I'll
can
start my reply if your lordship permits. My lord, the main issue that has been raised is, my lord, that the Section 21 notice was issued in 2019. My lord, but that Section 21 notice was issued by the person who I had authorized to issue the Section 21 notice under the first power of attorney. And then, my lord, it was never acted upon by that person. My lord, kindly see the gap in terms of years.
Section 21 notice was issued by a person who was authorized.
Who was
by you.
authorized? There is no dispute. We had given the power of attorney to the first person, Mr. R. Ravi Sundar. That is not the bone of contention. Now, my lord, this gentleman.
Just a moment.
Yes, sir. The date of the Section 21 notice is 30th September 2019.
What is the page? Would both of you do me a favor?
Yes.
Whenever you file your notes, give me an index of the documents, because
My lord.
papers are
Yes,
voluminous.
Various
at
documents,
times,
yes. And there are repetitions
pages
also,
are-
but we shall.
Just the important pages will do. And keep your notes concise. Don't make it 5 pages, 6 pages, 2-3 pages.
2-3 pages.
Only the points.
My lord. We shall do. Grateful.
I'll just indicate the page number.
Yes.
So, my lord, there was a reply from the respondent number 1 to this letter refuting the claims. Section 21. This was on 18th September 2019. Sorry, my lord.
18th September?
Sorry, my lord.
No.
There was a first they had given a notice raising the claims that was refuted by the 18th September reply. Then 30th September, Section 21 was invoked. There is no dispute.
You invoked the arbitration.
Invoked. So, my lord, after that, no step was taken. That gentleman who was really authorized never took any steps towards filing any Section 11 notice, appointing any arbitrator, or proceeding with the arbitration. Now, my lord, this gentleman was authorized by me under the first power of attorney, my lord, which is at page 173 of the petition. Now, my lord,
page 173 of
170
revision
of the my lord, main civil revisional application, volume 2.
Yes, this is your power of attorney.
Yes, ma'am. Now, if my lord takes clause 10, this is really the clause which grants power to the attorney to represent or appear before any court or arbitrator, sign all pleadings, all documents. Now, my lord, will find just above that, para 9, to delegate the powers vested in him above to any person. So, my lord, expressly, 1 to 8 was delegable. 10 and 11 after that, consciously, was made non-delegable. So, he did not have the power to delegate to anybody. So, the person who really had the power never took the step and could not have delegated the power to take that step.
Yes.
Now, my lord, if my lord takes page 175, second paragraph, next paragraph, in the power of attorney, my lord will find that the power of attorney is revocable by notice, expressly. This is not an irrevocable power. So, these are the two things about this power. So, my lord, from 2019, this gentleman takes no steps. Then suddenly, the application under Section 11 is filed on 22nd December 2022 by the present liquidator of one of the constituents of the joint venture. Now, this liquidator claims to have the power to initiate the arbitration under a second power of attorney, executed by the first attorney. This, my lord, is at page 184. Page, page 184, volume 2. Now, my lord, if your lordship takes page 185, the third recital. Whereas pursuant to clause 4.2 of the JVA, I was constituted as the attorney and accredited representative to do or execute in the name and on behalf of Messrs. Pratyusha AMR JV, wide power of attorney dated 30/7/2030. He says, I am the attorney under that. Then, my lord, next. Whereas clause 9 of the said power of attorney authorizes me to delegate the powers vested in me under the POA in relation to the project by execution of the power of attorney on behalf of Pratyusha AMR JV. So he expressly states, I have the power under clause 9. Then, my lord, however, if my lord comes to page 187, clause 8, the power to represent or appear before any court, arbitrator, is delegated, which could not have been delegated under clause 9. That is the crux of the dispute. So, my lord, the person who was authorized never took any step. So I had no reason to object. He never proceeded with that arbitration. The person who was later appointed as a liquidator of one of the constituent, not both, not the JV, one of the private limited companies, which is the constituent, he gets a power of attorney from the previous attorney, claiming to delegate a power which was never delegated. Then, my lord, he files the section 11 application. Then, my lord, the arbitration proceeds with. So, my lord, this is a case where a person has come before this court and before the arbitrator seeking to represent me without having the power to do so from inception. This is our case. Now, my lord, in this, we sought to intervene in 2 ways. Firstly, my lord, in the section 11, we were not aware that he has proceeded. When we became aware, there was a review petition pending by the respondent number 1. So we filed the intervener application there, that is still pending. Secondly, we tried to intervene before the arbitrator. My lord knows, 3rd minutes, we were shut out. We were not allowed to. The arbitrator's view was, there is already someone representing the JV, so you cannot come and represent. Now, my lord, after that, a section 16 was moved by the respondent number, my lord, the respondent in the arbitration. That was rejected. That was on same grounds that this person does not have any authority. So, my lord, the first legal objection which has been raised is section 16, once rejected, cannot be challenged at that stage. It can only be challenged at the section 34. Now, my lord, the difficulty here is the section 16 was moved by a party who is not me. The grievance is mine. I was shut out from the arbitration. I was not even allowed to be a party.
Who moved the section 16?
The respondent. So, my lord, what is happening is, there are only 2 members of the JV. The liquidator of one member has obtained the illegal power of attorney, and he is seeking to hijack the entire JV and proceed with the affairs of the JV alone. He is proceeding with the arbitration. He is affirming the statement of claim. He is affirming the pleadings. He is giving the evidence in the arbitration, all by himself without involving me. When I try to get involved, I am shut out. Another party moves, he is rejected. On certain grounds, my lord, I'll come to those grounds. Good, bad, ugly, my lord. I cannot challenge in 34 because I am not a party. My lord, my real grievance is that someone is representing me in a tribunal or a court of law who has no authority to represent. So, my lord, because this power of attorney is expressly revocable, when I see that the arbitration is now proceeding, in spite of my objections, nothing is being done, I file this application for intervening and withdrawing the claims. Now, my lord, first objection, there is section 16. I have no section 16 application. I cannot make a 16 application unless I am added as a party. If my lord sees section 16, only a party to the arbitration, before filing his statement of defense, can make an application under section 16 before the learned arbitrator. I am shut out. So I cannot file a section 16. So only thing I could file is an intervener application that allow me to enter and withdraw the claims. The second prayer may be subject to considering my submissions in that arbitration. So when my first prayer itself is rejected, I am not allowed. I have no other remedy but to come before this honorable court. Because my even section 34 applies after the award is passed. The time to file section 34 starts from the date a signed copy of the award is received by the parties under section 33. I am not a party. I'll never receive the award. I will never have a signed copy to come and file a section 34 application. And if I do file a section 34 application, the first objection which will be taken is I am not a party. Only a party can file.
Why do you want to participate to contradict the claim?
Because, my lord, the claim has been affirmed by a person who is not authorized by me. Does not take into account my views at all.
Do you intend to say that the claim is not there at all? There should be no claim at all.
No. My lord, I have prayed for withdrawing this present claim. I wish to participate. Thereafter, file arbitration where both parties' interests are taken into account.
So that is what I suggested on the last occasion. Why don't you intervene
if I now
supporting?
Yes,
this?
madam. Now, if I just participate,
And
I will have to support anything he has given. He has not even consulted me. I have not been part of the drafting process of the statement of claim. I have not even been shared the draft.
Can be permitted to participate subject to the condition that you don't contradict the claim. Because if you want to enhance the claim, well and good. But if you want to contradict the claim and want a dismissal of the claim, then you are acting against the interest of the JV.
My lord, kindly consider this situation where claims are made which are not tenable.
See, section 21 notice was in accordance to your wishes because you do not oppose the section 21 invocation also.
No, no, ma'am.
Now, if section 21 is in accordance to your desire or in accordance to the intent of the JV, and the claim that has been lodged before the arbitrator is not inconsistent with the section 21 notice, you don't have any reason to be aggrieved by that.
My lord, my difficulty will be,
you can participate.
Today I don't even have a copy of the statement of claim.
That will be submitted to you. But then
Yes, my lord.
If you want to contradict the claim,
yes, my lord.
If you want to contradict the claim, if you want to get the claim dismissed, that will be something which will be averse to the interest of the JV, and you being a constituent of the JV cannot be seen doing that.
My lord, the difficulty is this: a person is claiming to represent the interest of the JV who is not authorized. Today, my lord, all my claims, all my pleadings are signed by that person. So, my lord, in this kind of situation, I'll have no option but to rectify everything.
You can always supplement the pleadings. You can always supplement the pleading, enhance the claim, which will be in the interest of the JV. But if you are seen doing an act which contradicts the interest of the JV, then in that case, it becomes difficult.
My lord, if I do any act, well, just my lord, my question. If I do any act, today I have not done anything. Today, in fact, I have come and said the person is not authorized. I want to be represented because I am also an integral constituent of the JV. Till date, I have not said that there are no claims or the claims are frivolous.
Dismissal of the
statement of claim, which has been signed by a person who was not authorized. My lord, kindly consider, today a civil divisional application is filed by a person. The department will say you show your board resolution or your power of attorney. This second power of attorney is shown. First power of attorney is not shown where this power is not delegable. Perhaps the department itself would have stopped that divisional application. Now the stand which is being taken is as if there is a dispute between me and the other constituent, which is governed by the arbitration clause in the JV agreement. But that is not the case. My dispute is not with that party. My dispute is with a person who does not have right to represent me. Today, suppose he was not the liquidator of the other party. He was simply any other third party. And he was given this power of attorney by my attorney with whom I have made this express power non-delegable. Then, my lord, that arbitration clause would not apply to this dispute. So, my lord, the tribunal or court to whom a filing is made has to be first satisfied that the filing is proper. It is authorized. I may enhance the claim. I may tweak the claims a little. I may support it with evidence which they do not have.
That can be permitted even now.
That, my lord, kindly permits. that I will be allowed to
Mr.
have a claim.
Gupta, if he supports your claim, what is your problem?
Lord, firstly, he has asked for dismissal. Secondly, I'll tell you, Lordship, why
Suppose
he has asked.
that dismissal is not allowed to be, the prayer for dismissal is not allowed to be considered, and he is allowed to participate, supporting your claim, enhancing the claim, bringing documents in support of the claim. Where is the problem there?
But insofar as the intention is concerned, that is adverse to the interest of the JV. That is the whole basis of his prayer for dismissal. Because the petitioner here is a shareholder of the principal respondent in the arbitration, against whom the JV is making the claim.
That may be there, but that will be a problem only if he contradicts the claim. If he supports the claim, that doesn't matter.
The evidence is already closed.
Maybe it will be.
Evidence is already closed. Evidence is over. Well, now it's a final argument stage. This has been going on for 3 years, and the petitioner had knowledge since 2023 that this arbitration is going on. Formal notice was served on him. This is at this juncture, after closure of evidence, a third party comes, not even a third party, a constituent of the JV comes and says, "Will you dismiss the claim?" That is the malafide, that is for a writ large.
My lord, kindly consider this situation. I am being just shut out because, my lord, 23 when I got the notice, I intervened in the review because that is the stage where section 11 was passed. For review of that order, one party had already gone. I intervened in that review petition. Then, my lord, I attempted.
When did you get notice of the arbitration proceedings?
My lord, as soon as we came to know, we filed the review petition. There was already a review pending. I filed the
6th April 2023 at page 201 of my vacating application.
So, my lord, if my lord sees my intervener application, I am objecting from that date itself to this entire proceeding. It is not a case I have come at the fag end.
But I'm so sorry to interject. I'll also give the date on which they filed the intervention application. 6th April 2023 is when they were notified. 21st February 2024 is when they apply for intervention.
21st February
2024 in the review. These are the dates. And Lordship knows one of the arbitration time-bound process, it was already initiated. And they did not take any step whatsoever for getting the matter heard.
Third sitting itself, we attempted to, my lord, come in. That we were not allowed. Then we filed the intervener application. But third sitting, first sitting, my lord knows, directions are given for filing the pleadings, etc. Second sitting, my lord knows, then next date is fixed for procedural orders, etc. So third sitting itself, I have intervened. I was shut out. I went, my lord, filed this review petition after. Intervene in the review petition after that because review is already pending for that order. Then, my lord, when I see the arbitration is proceeding, I am not getting any relief. That is the stage where I come and intervene. Today, my lord, if I am permitted to give my version of the facts, the tribunal will be free to see which version is correct. Today, I don't even have their version because I have not been shared. Today, what is being invoked against me, I am a constituent member. A third party is proceeding with the arbitration invoking confidentiality against me. They say that I cannot participate in arbitration because of confidentiality. Where I am the two constituents, I am the second constituent. One party will proceed and say that the other party cannot because of confidentiality. That is the malafide stand being taken. But nothing prevents the tribunal to say my version of the facts, which if I may be permitted now, and my documents, they're not tenable. His version of the facts is correct. Well, kindly consider, he's a liquidator. He knew nothing about the project. He was appointed by the NCLT. He has only gone by whatever records he found from that company. Today, if a binding award is passed, which is nil, where the claims are rejected, I will have no remedy on that cause of action anymore. I'll be shut out completely. I have prayed for, my lord, kindly dismissal of that statement of claim, not dismissal of the arbitration. Because, my lord, that statement of claim is being...
Arbitration is never solved. Arbitration is the mode.
But kindly consider this situation, that party has filed a plaint before a court. My lord finds that party did not have the power. But what will be the remedy of the other party? But these situations normally arise where there's a partnership firm or a company, someone comes and represents and files pleadings.
But may I have a lordship's leave for 2 minutes?
Yes.
So, my lord, the legal arguments which are taken today, one is that there is a section 16 done by another party on the same grounds. But I was shut out even before that, from the 3rd minutes. I do not even know what application was filed. I only have that particular minute's decision because it's part of the reply they have filed to my intervener application. So from that, I come to know that previously this issue was taken. Now I am coming with a situation where I have expressly revoked that power of attorney. In any event, that was not necessary because that power of attorney did not authorize this power to be delegated. Now this liquidator has filed everything. Liquidator was never party to that project. My lord knows Liquidators Act. Once liquidator is appointed, he will call for the records of that particular company. He has no power to take the records of the JV also. Today, he has gone by the records of that claimant company and he has proceeded with something. Today, my lord, my intervener application, maybe the second prayer could have been rejected. That no, he at least has the power to represent one party. So you give your version. I will decide. That I would not have been agreed. Today, my lord, I have been shut out. My right to participate has been taken up. And my lord, today, if an award comes, then I'm bound by that award. I'm a constituent of the JV. Good, bad, whatever the award is, I will be bound by it without having a single say in the entire process. These are my submissions.
When will you file your notes?
Within a 1 week. 1 week will be sufficient.
Week's time, lordship.
Week,
Can file 1 week.
By Friday.
ওখানেই থাকবে অ্যাসাইন ম্যাটারে থাকবে
Your Lordship, upon instructions, I'm submitting that the learned counsel, Mr. Amit Kumar Pan, who is appearing in this matter, couldn't come to court because of some personal difficulties.
Very well.
So I'm paying for just 1 day's accommodation. As per my instructions, he is down with fever. He's down with fever, that's why.
When is the next date?
But the next date was there, but we have not taken any steps. Only thing, my lord, for my lord's assistance, we have prepared a short notes, my lord.
Give it. It will help.
I may have and a few judgments, my lord.
Very well. Next. What is that?
The court. 2-3 judgments, my lord.
Give it. I'll consider them.
Very good, my lord. আমি বাকি দুটো দিয়ে দেবো।
রেখে দিন ফাইলে রেখে দিন আমি দেখে নেব since it is not being taken up today he has paid for time
Very
লিখে নিন an adjournment is prayed for on behalf of
23, my lord, I am appearing for the state, my lord. My lord,
I appear for the
application,
petitioner,
my
my
lord.
lord. My lord, the state was to file a report, my lord. This is an
On
assigned
the
matter.
last occasion, my lord, there was a direction for filing a report by the state respondents, my lord. My lord, you have been newly briefed, my lord. My lord, kindly extend the time, as also, my lord, kindly extend the interim order, my lord. My lord, kindly allow us to file our report, my lord.
By what time will you be able to file?
3 weeks. 3 weeks, my lord.
But the interim order is subsisting till August, end of August, my lord. Lordship will kindly accordingly. I'm grateful.
Such learned advocate appearing for the state respondents.
3 weeks
seek further time to file report in terms of the order dated
সিম্পল জিনিস তো একটা ইন্টারভিউ দেখলাম আগে থেকে পিটিশনও দেখলাম
when was the order for filing report passed?
Lord, 16 June 2025, paragraph 6 of your lordship's last.
25.
Yes.
Full stop. It is submitted that 3 weeks' time may be granted. Full stop. As prayed for, comma, let such report be filed after 3 weeks. Full stop. The interim order granted earlier shall stand extended till the end of September 2026 or until further orders, whichever is earlier. Full stop. Paragraph. Was there any direction on you to take exception to the report? No.
There was but there was change of panel. First direction was that they should file a report. Consequently, that would be there to file.
Exception was there. 16 June order, it was there.
Yes. If kindly takes up paragraph 5 of the order of 16th of June 2025.
Exception, yes. Exception to such report may be filed within a week thereafter. List this
Kindly
matter.
grants us 2 weeks, my lord.
Exception to such report may be filed 2 weeks thereafter. Full stop. List this matter on.
That takes us to 18th, I think, my lord. 18th of September.
25th September 2026.
25th.
Only one indulgence, my lord. Lordship had the lordship had not directed them to serve a copy. I understand that they will nevertheless serve a copy of
If they don't, sir, how will you file an exception?
I'm grateful.
বলছি আপনি স্টেটের 25 26 এ অ্যাপিয়ার হতে পারবে কেউ জানে সেম ম্যাটার মিলর্ড
You are appearing?
No,
I'm not appearing, my lord, but I do not know whether if
but
anybody
the matters are same.
I will appear,
But somebody should be there for the state. If there is nobody
then I will appear, man.
For it to call করুন.
Lordship, Your Lordship,
No,
this,
25 and 26.
And I'll take it up. Serial.
Your Lordship, item number 24 is an income tax matter, but Mr. Sharma is appearing on the other side. He's my lord in courtroom number 7 before the Honorable Division Bench. But this matter, my lord, if my lord may recollect, this matter was heard before my lords. It is a case wherein your lordship, for assessment year 17-18, there was a demand. We had filed an appeal. Department kept adjusting beyond 20% for other assessment years.
Refund thing.
My lord, the refund thing. And the situation is that even after my lord, this matter was taken up, department has constantly kept adjusting. So and now there's nothing left for the department. Like probably very little amount is left. But my lord, the entire adjustment beyond 20% is illegal. We had, my lord, at the time of hearing relied on various decisions, your lordship. Even after, my lord, the hearing in this matter, the same issue has been considered by coordinate benches of this Honorable High Court, wherein, my lord, the same principle held in Danieli, India, then by my lords and Gaurav Enterprises, they've all been followed. And my lord, no adjustment beyond 20% can be made.
Another one which was subsequently delivered, that PS region,
My lord.
where Mr. Mojumdar appeared.
My lord.
There were a lot of other points also urged.
Because in this case, my lord, it's a vanilla case in the sense that, say, my lord, that there were, in fact, if I may, very briefly, because I will not want to touch too much, Mr.
What to do?
And may kindly keep it on 28. I've spoken to my learned friend as well, because he indicated that, my lord, he's before the honorable division bench, my lord. So I don't want to.
Likheni. Mr. Jhunjhunwala, learned advocate, appears for the petitioner. Full stop. The respondents are not represented. Full stop. As prayed for, this matter on August 28, 2026.
Actually, next week when I have some personal difficulty, that's why I'm grateful, Your Lordship.
হ্যাঁ 24টা হলো হ্যাঁ
Yes, Mr. Basu, you are appearing here.
No, my lord, since nobody is there, my lord, if your lordship pleases to regularize
Actually,
then I can
the
appear.
property and disputes, my lord, are almost same. It relates to Monglahat property, and the challenge laid down in 3 writ petitions are almost same. Therefore, may I give a copy to my learned friend, because
None appears for the state respondents. Full stop. However, comma, Mr. Basu, Mr.
Devasis Basu.
Devasis Basu, who usually represents the
for KMD.
I am a
আচ্ছা sorry ঠিক আছে
I'm grateful, man.
বিদ্যাকে দেখতে পাইনি ভাই গ্রেট ঠিক আছে
26 also is there.
Pardon?
26?
26.
26 my lord, same order, my lord. There are 2 petitioners.
26 se same order.
Same order as 25.
Ramdas, 26 ke same order kore diyo. Mr. Basu, you will appear in 26.
বলছি দাদা আপনার নামটা একটু লিখে আর ফোন নাম্বারটা দিয়ে গ্রেট
27, Lordship, I beg to appear on behalf of the petitioner.
I am appearing for the private response.
State was there on the last occasion, today state is not there.
What is your matter?
My lord, the grievance of the petitioner is that a property which was a gift property which stood in the name of the predecessor of the petitioners as well as of that of the private respondent has now been a deed of gift has been executed by the refugee rehabilitation department solely in favor of the private respondent in contravention of a previous order passed by this honorable court. Lordship, if my lord kindly takes up page 83 of my lord's brief.
83.
Page 83 starts at 82. 82, the cause titles are there. Lordship, page 83.
83.
Lordship, this is at the instance of my learned friend's client. Lordship, petitioners being the legal heirs. May I place, Lordship? Petitioners being the legal heirs of the original allottee, Surjokanto Chondo, since deceased, have assailed the order passed by the Deputy Refugee Relief Commissioner, West Bengal on June 20, 2022, wherein the commissioner observed that while initiating the process for issuance of freehold title in favor of the legal heirs of the original allottee, total area of the land shall not be more than 2 1/4 kathas in respect of such and such of Bidhanpolli colony as per terms and conditions of the letter of authorization dated 15th February 1967 issued in favor of the original allotee. So, Lordship, both the parties who are before my lord, all the parties who are before my lord, they are claiming through Surjokanto Chondo, who was the original allottee. I shall not trouble your lordship with the rest of the order. Kindly takes up page 86 once. This is the concluding part of the order. The second paragraph, Lordship, I shall place. In view of the above, the court is inclined.
We have served a notice on the government leader in terms of the earlier direction.
Yes. The attack.
Why is nobody appearing?
A gentleman was there, Lordship, on the last occasion. My senior friend, he was caught up in another court. But
No,
today,
but last occasion, his name is recorded. There was a direction to serve on government leader only because nobody was there.
yes, thereafter, last week when this matter was taken up, my senior friend was engaged in another.
Matter was passed over last Friday.
Then, because Lordship, the answer has to come from the state whether they have given me an opportunity of hearing.
Only one thing, one submission kindly comes to the relief sought for. He prayed for cancellation of my deed. But the deed has been executed by the RR department pursuant to the order passed by this honorable court in that writ petition which my learned friend shows. So until unless that order not challenged.
Yes,
so, this is the consequence
my
here.
very case, Lordship, will be based
And
on the fact that
several litigation took place. I have
those are all previous
all orders
litigations.
is there. I shall hand over my
Lordship, my entire case hinges on the fact that there was a direction by this honorable court, as I was about to place, that an opportunity was to be given to all the legal heirs of the original allottee to be heard, and thereafter a deed of gift could have been executed. My very case is I was never given that opportunity pursuant to this order, and the deed has been executed now in favor of my learned friend's client.
That is not the case.
Because it has to come from the state to show that they have given me, they have complied with the order.
Opportunity was given pursuant to the order passed by the Honorable Justice Rao. In that deed, the area of the quantum of the land was lesser. So I have to file another writ petition. In that writ petition, the Justice Ghosh
direction was to hear you also.
Yes, that is where I was coming to, Lordship, page 86, second paragraph. In view of the above, the court is inclined to hold that the petitioners, here the petitioners were my learned friend's client, along with other legal heirs of the original allottee. So, Lordship, I claim to be one of the, it is an admitted position, it is not a claim. I am an legal heir of the original allottee, are entitled to freehold title deed in respect of 4 kathas, 14.5 chitaks of land in the plot in question in terms of notification dated such and such. So, Lordship, thereafter, Lordship will kindly come. Lordship will kindly come to the last paragraph of page 86. Since notice has been issued by the said authority upon all legal heirs, including the petitioners, for putting their signatures on the site plan prepared by the authority on basis of concrete record and effective possession, the second respondent is directed to take.
Who were you in the earlier writ petition?
Lordship, I was not a party to this writ petition, but Lordship will kindly take up the next page after affording reasonable opportunity of hearing to all concerned, including the petitioners, in accordance with law. So, Lordship, opportunity of hearing to all concerned, previously, Lordship, qualified by the legal heirs of the original allottee. So, I say that I am the one of the legal heirs of the original allottee in the same footing as my learned senior friend's client. So, Lordship, I should have been afforded an opportunity of hearing. That has not been given to me. This is, Lordship, what my learned senior friend has indicated. That was pursuant, that was a order passed by Justice Krishna Rao. This is subsequent to the order passed by Justice Krishna Rao. This is Justice Shubhra Ghosh's order, which I am placing, of the 5th of January 2024. So, Lordship, my grievance is that I was not given an opportunity. Now the deed of gift has been executed solely in favor of my learned senior friend's client.
Correct. Kindly take up this bunch of kindly include some marking in here.
Yes.
This is the first copy. The first repetition was filed being WPA number WP 31 W of 2016. In that repetition, the department issued a submitted a report, and that report relying of the notification or petition that says in the effective position who is are entitled to get that. Now that in that petition, my learned friend's client, not another legal heirs, filed an application for addition of party. That was allowed. This honorable court directed to consider their and the subsequently the authority the passed an order. Now passed an order but says they are the one of the legal heirs were heard. Now in view of this notification, they are not in effective possession. So subsequently authority held that since they are not the effective possession, other legal heirs will get the according to their proportionate share. I have annexed all these order. Now the last order the last order relates to only the execution of the deed. In the previous kindly in that branch kindly take up
this second the petition 31 of 2016 was preferred by whom?
Preferred by one of the legal heirs, Anjali Sarkar, when the petitioner before my lord was the power of attorney holder of that Anjali Sarkar. In that petition, I was the party respondent. That petition was now next page in this branch, page 2, my lord will find the one can was filed and that was disposed of. Thereafter, my lord, in terms of the order passed by this honorable court, kindly comes to page 5, Anjali Sarkar matter, the authority dispose of this matter, challenging that order. Therefore, it is kindly page 7, kindly see the ordering portion. Therefore, it is directed to regularization of section RR department to initiate a process for issuing freehold title deed in respect of such and such by including Anjali Sarkar's 1/4 share according they are entitled to occupy in the light of the letter of authorization. Now, this order was challenged. I filed this petition WPA 9014 of 2020. That was disposed of by Justice Rao. The internal page 7, in view of the order, the impugned order passed by the respondent number 2 dated 14/2/2020 set aside and quashed. The respondent number 2 is directed to reconsider regarding the issuance of the freehold title in favor of the legal heirs of the deceased Anjali Sarkar by substituting the name of the legal heirs deceased Anjali Sarkar by taking into consideration the guidelines 1917 and the report dated such and such submitted before this coordinate bench in WP number 31 W of 2016. Now, pursuant to that order, the hearing took place. Kindly comes to in this branch, the authority passed an order. Page 26 in this branch, the ordering portion. Hence, it is ordered that comprehensive representation application of the legal heirs of the deceased Anjali Sarkar is rejected, and this office has no scope to extend any relief to the legal heirs of the deceased Anjali Sarkar. Now, the Anjali Sarkar thereafter no this order not challenge. Authority held since
he is claiming through Anjali Sarkar.
No, he is the separate another legal heirs Rotin Chando.
So this rejection does not hurt him.
Yes, now kindly see, it is directed the deputy controller. Now eligible legal heirs of Surjokanto, total area of land shall not more than 2 1/4 katas in respect of such and such. Now again I challenge this repetition on the ground. Kindly comes to first page. In the first page, the authority find that 1, 2, 3, 4, 5, 6, 7. Again repeat thing. Total area of 4 kata and 14.5 chitaks of the above legal heirs are maintaining effective possession. So when the authority now thereafter I have challenged this order. Initial clause 2 that was the recorded in the final order. In the clause 2, 2.5, and thereafter that is the recorded in the writ petition 7632 of 2013. Now this honorable court directed that should not be 2.5, that should be 4 and 14 4 katas and 14 chitaks and half, and according to the share and according to their the map, deed was executed. My learned friends clients also they got according to their share and the map is there. That is not the authority and the order also does not speaks about that directed to entire share upon us. According to petitioner and all the legal heirs according to their sketch map. And after that order,
Mr. Banerjee, if you have got your share, then what is your problem?
My lord, the share that has been allotted to my learned senior friend's client that originally stood in the name of Anjali Sarkar. Lordship, that ought to have been allotted to the legal heirs of Anjali. Lordship, where my learned senior friend says at page 86, I had showed that when my learned senior friend had challenged the order that of 2022, which I do not have a copy of that order, Lordship, but Lordship kindly takes up page 86 for once.
Yes.
In view of the above, this court is inclined to hold that the petitioners, along with other legal heirs of the original allottee, are entitled. So, Lordship, it was the petitioner that my learned senior friend's client he was representing there, who are now the private respondents. Also, my share was also to be taken into account because he separately has his own share as I have my own share. The deed of gift, Lordship, which has been executed by the refugee rehabilitation, this is the portion which was to be allotted to Anjali Sarkar. So my learned senior friend's client cannot solely now come and claim that just because that has been recorded in his name, he has his own share. This is an extra share which has now been recorded in the favor of my learned senior. And that is the part where I am aggrieved because the court was very specific on the direction that the original legal heirs, all the legal heirs.
It is extra.
Because, Lordship, the part where Anjali Sarkar, Lordship, it was divided. There were 4 legal heirs. We have got our share. My learned senior friend's client, they have got their own share. Another brother has their own share and has his own share. And this share, Lordship, it could not have been vested upon my learned friend's client solely by way of. So, Lordship, that is why the court passed an order that all the legal heirs have to be heard. It could
no, but Mr. Ghosh's client would also have a share in this 4 kata 14.5 chitaks.
Yes, he has his share as I have my share. But this is the share which is with regard to Anjali Sarkar.
He is claiming through Anjali Sarkar only.
No, she is our sister of his client and my
original allottee was whom? Let us have this.
Surjokanto Chando.
Kindly see the first page. This report the details. Name of the original allottee and who has the
Surjokanto, thereafter Indu Bhushan.
After his death, present occupiers were in the Indu Bhushan Chando, Satyendra Bhushan Chando, Krishna Bhushan Chando, and Binoy Bhushan Chando. Now this Indu Bhushan Chando plot 84 by gifting the possession the Krishna Chando. Later, the plot was mutated in favor of Satyendra Bhushan Chandra. That now
Who is now before this court?
Rothin Chandra.
Matlab the legal heirs of
Rothin and
claiming through whom?
Matlab Satyendra Bhushan Chandra. Matlab now legal heirs of the Satyendra Bhushan Chandra, Rothin Chandra, Swapon Chandra, Tapon Chandra, all sons, and Krishna Bhushan Chandra, Srimati Lokhi Chandra, wife, and Somit Chandra and Subit Chandra.
You have a copy of this?
Matlab,
This, please,
Matlab,
please, because this can solve a lot of problems. It
And
shows
then my
that
learned senior friend can file an affidavit to that effect so that we can
Matlab.
deal with that. And I shall set out a genealogical table also because that will assist my lord.
Having heard learned advocate,
My lord, I am for the opposite party led by Mr. Tanmay Mukherjee. I am paying for adjournment. My lord, kindly fix it after 17th, my lord.
Lord, adjourn, my lord, what happened, my lord? Trial, my lord, has, my lord, imposed court upon me, my lord. Who? My lord, the learned trial judge, my lord, for taking adjournment for at
when
least
is the
trial.
next date?
My lord, in the meantime, what happened, my lord? The order of injunction, my lord, has been directed to be implemented against me through police help. Well, police is also disturbing me. That is the whole difficulty.
After Monday, my lord, kindly fix, my lord.
But if you last time also time was taken,
that
if
time,
you
my
take
lord,
time here and you implement the order there, then that is difficult. That can't be done. You either you
Well,
do it.
yesterday order yesterday only. Yesterday, my lord, the order passed, my lord, for police help, and that order has been
here. Don't do it there also. That is not right.
This date was fixed for hearing, and after
You had
hearing,
taken
order
time.
has been
You had taken time on the last occasion. Today also
yes,
you
may I
are
kindly
taking
see,
time.
my lord. Hence, I see Shibpur PS is directed that the order dated 22nd 7 to 2024 is implemented properly by all concerned according to its law and spirit. Let the copy of this order along with the injunction order dated 22nd July 2024 be forwarded to the I see Shibpur PS for necessary action. This is they are enforcing ad interim. Now, my lord, kindly see the next line. 18th February 2027 for hearing of the injunction application. Ad interim order is extended till the next date.
And what is the injunction? Not to disturb my possession. I am the plaintiff.
And my application under Order 7 Rule 11 has been rejected. My lord, I have challenged that.
And my
I can, my lord, satisfy herein also, my lord, 77 Supreme Court, my lord, applies, my lord, Justice Krishna Rao's judgment, my lord. Apt case. I can say that. But I don't let if my learned friend wants after 17, my lord, kindly takes it up after 17. I don't stand.
21st.
21st. Very well. But at 12 or my lord, at 2 any time.
ये दीदी 21st একটা
এই এটা কি ছিল গো? ও, আরে বাবা রে, অ্যাপিয়ার করছেন না কেন? কতবার নোটিশ দেবো?
কেন তারপর আর আসেনি তো লিস্টে।
আগের দিন আবার নোটিশ দিতে বলছে, ছিলেন না।
হয়নি বলছে লিস্ট।
আপনি সবাইকার হয়ে অ্যাপিয়ার করছেন?
না
এখন ঢোকা
1 আর 4 to 8
31 তো
টাকা আছে, সার্ভিস হয়ে গেছে তো অসুবিধা কি?
My lord had directed me to serve upon the non-appearing, my lord, opposite parties, my lord. Substitution application was allowed. My lord, there is also an application, my lord, for extension of interim order. My lord, kindly see your lordship's order dated 20th March 2026.
কি হলো দিদি, ডিপার্টমেন্টকে দেননি ফাইলটা? সাবস্টিটিউশন হয়নি কেন? কেন? এটা তো ঠিক নয় না, অর্ডার থাকছে, তারপরে 16 তারিখের অর্ডার।
সেটাই হয়।
আজকেই করতে বলুন, at 2 PM come back, let the records be corrected.
Lord, a resolution has been taken, my lord, from 2 PM. Bar has adopted a resolution, my lord, due to, my lord, an unfortunate demise of a very junior member of the bar, my lord,
What has happened?
expired. Cause, my lord, I do not know, but I am told he's a very junior member of the bar.
Citizen Gold.
My
When
lord,
is the next date before the
my lord, next date, my lord, I have filed an application, my lord, for extension, my lord.
I will extend it. I'm keeping it on Monday as to be mentioned. In the meantime, let the substitution be done because it will be এটা পাঠিয়ে দিন, এটা ঠিক করুন। হচ্ছে না তো, অর্ডারই হচ্ছে না, সাবস্টিটিউশন হয়নি।
My second affidavit of service, my lord.
অ্যাফিডেভিট অফ সার্ভিসটা ওনাকে ফেরত দিয়ে দিন। মানডে টু বি মেনশনডে রাখবেন এটা। It will appear as to be mentioned on Monday.
Yes.
লিখে নিন, একটা অর্ডার লিখে নিন।
Eighty. Great. সেই জন্যই তো আচ্ছা বসছে আজকে। ও আচ্ছা, কর্পোরেশন দেবে কি এতে দেবে?
But I'm the defendant in a suit for ejectment. But here, my lord, after the suit was instituted, 7-1 application was filed. 7-1 application was allowed. And then, my lord, the plaintiff prayed for withdrawing whatever amount that I have deposited in the court. That was allowed. I prayed for recalling. My recalling application was dismissed. Now, my lord, the issue here is that the landlord, the plaintiff, has failed to pay the corporation tax to the Kolkata Municipal Corporation, by reason of which the corporation has attached the rent under the KMC Act. Now, after a rent is attached, the tenant is obliged to pay rent to the corporation, to pay rent as a property tax to the corporation. Now, if that happens, then well, there is no rent payable to the landlord, to the plaintiff. A 7-1 application was filed, well, I understand, as a knee-jerk reaction. Whenever a suit for ejectment is filed, a 7-1 application is filed in due course. But when the defendant, the tenant, is paying rent to the KMC, for the default of the landlord, then my lord, 7.1, 7.2 and 7.3 will not be applicable. And my lord, my defense has been struck out because I have not deposited the rent in court. Whereas I have been depositing the rent to the KMC to the satisfaction of the attachment which the KMC has made in respect of the property tax. My lord, may I rely on page section 195 of the KMC Act, which is a non-abstentive clause. Attach it. A copy আছে? But I have one copy. Sir, may I place the section and hand it over? Section 195, recovery of property tax on lands and buildings from occupier. On the failure to recover any sum due on page section 195 of KMC. On the 195.1, on the failure to recover any sum due on account of property tax. Thank you.
190?
195, subsection 1. May I place 195? On the failure to recover any sum due on account of property tax on any land or building from the person primarily liable, therefore, under section 193, the municipal commissioner shall, notwithstanding anything contained in the West Bengal Premises Tenancy Act 1956 or any other law for the time being in force, recover from every occupier of such land or building by attachment of the rent payable by such occupier portion of the total sum due, which bears as nearly as may be the same proportion to that sum as the rent annually payable by such occupier bears to the total amount of rent annually payable in respect of the whole of such land or building. This is the section which is applicable in the present factual circumstances, because property tax, non-payment of property tax by the plaintiff or by the owner of the property, municipal commissioner takes steps for attachment of the property tax, attachment of the rent, notwithstanding anything contained in the Premises Tenancy Act. Now, under the Premises Tenancy Act, whenever a suit is filed, unless the tenant deposits the rent, the agreed rent or the disputed rent, under section 7, the defense of the defendant is struck off.
Yes.
That is why section 7, the rigors of section 7 or the penal consequences as contained in section 7 will not be applicable to a defendant who is paying rent to the corporation by virtue of section 195 of the KMC Act. Now here, my lord, certain steps have been wrongly taken. My lord, I shall admit that. After a suit was instituted, I filed a section 7.1 application. That was a wrong step on my part, because even before that, I have been paying rent to the corporation.
There was nothing due and payable.
There was nothing due and payable. And I have documents, I had annexed here. I had annexed before the trial judge as well. So the 7.1 was allowed. Then the plaintiff, the landlord, prayed for withdrawing whatever sums that I have deposited. That application was also allowed without service to me. Now, when I came to learn and I applied for recalling of that application, that recalling was dismissed. Plaint was required to be amended. The plaint was allowed to be amended. Now, I file an application before the trial judge, praying for a clarification as to where I should deposit the rent, before the KMC or before the court. That application was dismissed by holding that I've already passed an order under 7.1. You have not deposited the rent. Your defense is struck off. I can't do anything about it. This is the basic dispute between the parties. Well, Your Lordship kindly takes the documents by which I say that I have been depositing rent before the KMC. Kindly sees page 45. This is the attachment of rent by the KMC.
Page 45. Yes.
This is there is no dispute as regards whether the rent has been rent has been attached or not, whether there is a default on the part of the plaintiff or not. Whereas it has been found from our books of records that Sri such and such Anil Kumar
This is
Saxena.
what, a residential premises?
Yes, residential premises. Right. Being the recorded owner of premises number such and such Kid Street has failed and or neglected to make payment of property tax to KMC. As a result, presently, the outstanding for the said premises and SSC number is found to be recorded as such and such. Now, in terms of Section 195 read with Section 225 of the KMC Act, Municipal Commissioner has been pleased to attach the entire rent of the premises and SSC number in question and as stated above for realization of the outstanding property tax. Hence, in view of the above, you are directed to make payment of the rent payable by you to your landlord directly to the Kolkata Municipal Corporation Office of such and such till the municipal commissioner is satisfied that necessary recovery has been made. This is the sum and substance. This is in case of any other attachment. Now, Lord, kindly takes page 46 onwards, 46 to 61. I have annexed documents to substantiate that I have been making payment of the rent to the KMC. Now, this was the landlord's obligation to pay rent. He felt that is why I had to. And it is a mandatory provision. Otherwise, the property would be attached, sealed, and then sold off under the provisions of the KMC Act. Now, the landlord cannot take advantage of his own wrong. The landlord cannot take the benefit of Section 7, saying that you have not deposited rent. And that is why your defense should be struck off. That may be the mandate of the statute. But that is also notwithstanding anything contained in the KMC Act. KMC Act overrides, Section 195 overrides Section 7 of the Premises Tenancy Act. Where the reverse, it is not the reverse case, because only Section 8, that chapter of the Premises Tenancy Act has overriding effect on all other laws, not Section 7. The Lordship kindly takes Section, the West Bengal Premises Tenancy Act 1997.
Page. Yes.
But,
Section 7.
Section 7. But I need not place this section, Lordship knows it very well. But I'll only place the second, the next section, which is Section 8, which comes under Chapter 4.
Yes.
Section 8 says only Chapter 4 to have overriding effect. Provisions of this chapter or the rules made thereunder shall have effect, notwithstanding anything inconsistent therewith contained elsewhere in this Act or in any other law for the time being in force. Section 7 does not have any overriding effect. But in these circumstances, but I have, as I said, Section 7(1) application was a mistake on my part. But even if I have filed a Section 7(1) application, when otherwise, the landlord cannot take benefit and the court cannot shut its eyes on the documents on record, which satisfies Section 225 of the Kolkata Municipal Corporation Act. This is the long and short of. I can refer to the other documents, the orders and the applications. This is my principal argument, insofar as the case is concerned. And the suit is proceeding. Issues have already been framed. Next date in September is fixed for evidence. And I have no defense.
Finish it off. Mr. Chatterjee, how long will you take?
I'll take 10-15 minutes maximum.
You can have it next Friday.
Huh?
Because 2 p.m. Mr.
Yeah, my lord, I will not appear. My lord, they are 28-year-old child. He passed away, my lord, in his sleep. He's nothing. He just had
next
a little bit of
next
sugar.
date is in September. We can
Next
have it.
Friday, my lord, there is no problem.
But I'll only cite one judgment. I do not have a copy of it. I'll hand over the judgment to my learned senior friend. I'll cite it and then
Likhen. Heard Mr. Dasgupta. দিয়ে দিন ওনার বইটা দিন।
My lords, before my lord rises, extremely sorry, my lords. My item is item 34. So
I have not interfered with the order impugned. I have allowed the petitioner to apply for preponement, which application if made, the learned trial court will, the appellate court will prepone the date and hear it.
Very good.
Disposed of.
বলবে তো judgment copy করে আছে
There was a direction to file a supplementary. Yes.
It's prepared, we just skip my direction.
Not a problem.
In the batch.
We are also a little bit in default. Lordship wanted us to prepare written notes of arguments.
Do it on the, I'll in any case keep it on one more day so that I can get myself acquainted with the papers. Lot of papers handed up in
Then in
several
that case,
pages.
the Lordship will take the supplementary affidavit and record. I have made most of my submissions on the last occasion. Well, I can just prepare that because your Lordship wanted a bullet point note. We have a note, but I have to
Only indicating the pages will do because with this volume,
yes, it's become
sifting through the pages becomes a possible.
No, I'll also not prepare it.
Then what we can do is instead of repeating the arguments, because I have made the crux of my arguments already. There are two judgments that Mr. Chaudhary cited, which I have to deal with. And there are other subsidiary arguments that he had made. I can briefly indicate this to you, your Lordship, but I can make a comprehensive, very short argument on whenever your Lordship is planning to keep it next and finish it. Because I can then come with my written notes. Today, in any case, I don't understand whether there are very conflicting resolutions of the bar.
Then I have now decided that I will appeal.
No, whenever there's
It's a matter of personal choice. Because they're all void, not binding, so might as well.
It's not a matter of either treating it to be void or valid. If you today say that you're a member of an association and you do not wish to be bound by the resolution of the association, then you have to secede your membership.
But I don't agree with that. Why should I give up my thing? This is something I've been facing for a long time. But last time, at the meeting also, we came up with one every meeting also. I said, you can't. How can you take a resolution? You write your name. You tell them, you write your name, sign, I want. I'll send it by post to the Supreme Court. Lordship knows what happened in Odisha. Then you'll find it all disappear. Last time, bar library meeting, I said, please, you can shout at me, I have no problem. All my friends. But then you put your name, sign, you find that nobody is there.
Just in that case, I think instead of troubling your Lordship twice over, we can do it with the notes. Or I am prepared to argue. I have virtually.
Up to you, entirely up to you.
No, whatever is convenient to my learned friend, I am not.
I do not want to want your Lordship to take down notes and then give your Lordship a brief written notes and then repeat the arguments. I am otherwise ready. I have made most of my submissions.
We can have it then next Friday, Mr.
Yes.
Your dates are nearby.
This is in September.
No, that
It's in October, so there is no rush.
that we are protected. So, my lord, if your lordship is finds it convenient to keep it next Friday, I can just, my lord, come with a brief. We have a written. But, my lord, I don't think your lordship.
I'll keep it on next Friday. On that day, you file your supplementary as well then. Or if you have it ready, you can.
We have it ready. We have handed it up, my lord.
আমাদের একটা কপি দিচ্ছি
ও এটা লিখেন supplementary Okay. তো না থাকলে নট টুডে করে দিন এখন তো আর রেজলিউশন আছে না ফার্স্ট অর্ডার তো হবে না
I had mentioned.
And for the opposite particular,
because of your resolution if
that I think I should not.
And for the petitioner, my lord, I'm being led by Mr. Jishnu Chaudhary. May I? Yes, my lord. 35.
A very interesting matter, my lord. But I don't think this is that Tuesday, my lord, if your lordship keeps it.
It will go up next Friday.
আর অসুবিধা হবে না তো বাড়তে দেবো
না তুমি রিস্ক নিও না
and I do not want to take any
No,
risk.
we should not get into trouble.
We'll have it on next Friday.
Next week. To never cause inconvenience.
37, not I am for the opposite party, but because well, today I have something to say.
In item number 38, my lord, I am appearing, my lord, for BSc Limited, respondent number 4. My lord, I know today the matter may not be taken up for hearing. May I file my affidavit in opposition only?
If you have it ready, you can file it. Not a problem.
Yes, my lord, I am filing it, my lord. Let it be kept on record. I have already served it. I have already served it.
Mr. Basu, there is no one in court to hand it up to my.
Okay. Then, my lord, my clerk is said he is there. He will hand it up to the
There's no
officer
one
of your lordship. Okay, my lord. Then next Friday, my lord.
next Friday.
Grateful, your lordship.
Yes, yes. No, somebody has given it.
Let it be kept on record, my lord. No reply has been filed, so only let it be kept on record.
ठीक है नहीं जाना था item 28 কত
38 my lord.
দিদি এটা স্পেশালি ফিক্সড বলে আসছে কেন স্পেশালি ফিক্সড নতুন ভুলভাল হেডিং এ দিয়েছে affidavit in opposition filed on behalf of the
BSc Limited, respondent number 4.
Filed on behalf of the Bombay Stock Exchange Limited.
My lord, it is BSE Limited now, no longer Bombay Stock Exchange Limited.
Filed on behalf of BSE Limited by Mr. Basu, comma is taken on record. None appears for the petitioner. You have served a copy of this on the petitioner?
Yes, my lord. Yeah, long back, my lord.
Mr. Basu submits that a copy of the opposition has already been served upon the petitioner. However, comma, no reply, no copy of affidavit in reply has yet been served upon him. Full stop, paragraph. Since the petitioner is not represented, list this matter on.
My lord, I am appearing for the respondent number 2, SEBI. I shall also file my affidavit in opposition.
Hello, Mr. Yes, Jagger, niche arrow likhe din. You have received a copy of affidavit in reply?
No, no.
Onar naam ta likhe din. Such and such appears for the respondent number 2 and files affidavit in opposition on behalf of the said respondent. Full stop. Niche likhe din. It is submitted by both the learned advocates that no copy of affidavit in reply has yet been served upon any of them. Full stop. To the comma to their respective affidavits in opposition. Full stop, paragraph. Since the petitioner is not represented, list this matter on 28th August 2026.
Much obliged, your lordship.
Next.
Suppose the petitioner while paying for
Not today. Resolution you have.
Resolution adopted.
The bank, my lord, in this matter, my lord, some negotiations are going on. It's a landlord-tenant dispute. But some negotiation is going on. They'll be sitting on 25th of August. So anytime after that, I'll be able to do.
26 after 26.
After 26. And a lordship maybe a date may be fixed after 26.
Likhe nahi, Mr. Likhe nahi.
42.
42 Act Order. None appears for the petitioner. Full stop. Learned advocate appearing for the respondent bank submits that talks of negotiation.
Uh, 36 why, my lord. Let us 36 why I am for the respondent one.
Very well. I have passed it over. Not today. It's not today. Next.
34. Okay. Thank you. Please get.
44. I am for the petitioner.
Respondent is not there.
Huh?
Your other side is not there. What have? Next. Original side quarter. अपन तो फालतू